defendant's objection to appointment of the reunification counselor. Obviously, in reading the pleadings, there's a dispute on many of the matters. So what the court intends to do is the additional dates where there's been a denial of parenting time, we'll set that for evidentiary hearing with the hearing that we are going to schedule in this matter. So we hear all of those at the same time. Also, what the court will do as it relates to the change in school, the court will expedite that hearing. We'll be in touch with you probably on Wednesday, and we'll get a half a day where we can do that expedited hearing on that. So what I guess today I'd like to hear is a defendant's objection to Ms. Queta as the reunification counselor.
Thank you, Your Honor. Your Honor, our firm filed our appearance on behalf of Ms. Ortiz on the 21st of June. We do have the luxury of hindsight with the YouTube recordings of hearings, so we have had an opportunity to look at those. And as it relates to the counselor, Your Honor, we've identified our thoughts regarding the fact that Ms. Ausler is more qualified, but I think it's important to look at kind of the sequence of events that have occurred here. There was an argument, and it was back on May 30th, 2023, and the subject matter of who is going to be doing the counseling. Ms. Ortiz's counsel at that time, Ms. Bailey Hobbs, had indicated that she had yet to review a correspondence that Mr. Sullivan had forwarded to her with her client, suggesting that Ms. Queta be used. The court went ahead and ruled that Ms. Queta would be the counselor unless there was an objection filed within 7 days, which there was. There was an objection filed on June 5th. On that same date, which in essence should reserve the question for the court's determination. On that same date, Mr. Clark went and met with Ms. Queta. That day or the next day advised Ms. Ortiz that, oh, by the way, you're to take our daughter Emerson to the therapist tomorrow for a meeting between she and Ms. Queta, which is extraordinarily odd given the fact that the parties were supposed to be involved in the process, that it would seem highly unusual that simply one parent would go talk to the counselor and then now the counselor is meeting with the child. I think that the idea was that both parents would be engaged and it would move forward from there. That being said, Your Honor, I think that so the sequence of events is clearly indicates that there's been no action by Ms. Ortiz to delay anything. She simply is of the belief that we are going to have somebody provide this service. They should be the best qualified to enhance the opportunity for rapid success. We've identified in our pleading that Ms. Queta, at least on her public information, does not seem to indicate that she has any level of expertise in either reunification or even dealing with children. I have spoken with the guardian ad litem in this case, Mr. Parks. He has a conflict or he would have attended this morning. Mr. Parks indicates that he's had no experience with either of the therapists. He's heard of Ausler. He knows her work. As far as Queta goes, he knows nothing of her. So there's no insight that he would have into this matter. Your Honor, obviously it's the court's decision, and whatever the court's decision is, we will abide by it and expedite our cooperation in the process.
Okay, thank you. Mr. Sullivan?
Your Honor, as I indicated in our answer, contrary to the representations of defendant's counsel, Ms. Queta, who the court indicated would be the counselor unless there was a reason she shouldn't be, is highly qualified to do this work, has previously provided reunification services to this court, and has extensive experience in providing counseling to families and adolescents. And I provided several points within the answer to the objection, which indicates her service to the community and also to this court. So the essence is that she is qualified. She's served in this capacity for this court before, and that's who the court has ordered. So there's no reason not to have her. It's not a matter of competing counselors. It's a matter of if there's a reason to find that she's not qualified, then perhaps the court would change its mind. But she is qualified as outlined in the answer.
Okay, thank you. Anything else, Mr. Toth?
Your Honor, again, I would say I think the sequence is important. I think Mr. Sullivan's taking a bit of a liberty with the order of the court, I believe, was in recognition of the fact that the defendant had no information, had no communication regarding Ms. Queta. I can't comment why that happened, but it did. So I don't think that on May 30th, the court was identifying that, yes, Ms. Queta is the best person to do it.
Indicates that her pleading a desire to have a different counselor. So I think based on that, we are between Lori Queta and the counselor that they seek to.
Okay, Ms. Hobbs, Bailey Hobbs, why would Ms. Queta not be appropriate?
Your Honor, I did not receive that correspondence. I received a proposed order, but I did not receive correspondence regarding Ms. Queta. So
Okay. Did the order state utilizing Ms. Queta?
it did not.
Okay. Might go back to my original question. Why is Ms. Queta not appropriate?
Your Honor, I have not had a chance to discuss that with my client. I don't have an answer to that at this time.
Okay, what I'll do in that regard is the court would appoint Ms. Queta as the counselor unless the defendant files some specific objections as to why Ms. Queta would not be appropriate within 7 days of today's date.
Only name on the table at that particular time. Thank you.
Thank you. Well, I think to some extent that Mr. Toth is correct. At that time, we didn't have anyone else, and Ms. Bailey Hobbs had not, as stated, had not reviewed anything on Ms. Queta at the particular time. I've had Ms. Osler on other matters before the court and has always done an excellent job. The court obviously wants all of the parties to be, again, comfortable in this matter and comfortable with the counselor. So I think either one of the counselors is qualified and could do that. It just appears obviously that the defendant is not as comfortable with Ms. Queta as with Ms. Osler. And obviously we have to have that comfort level so that the parties do, if you would, kind of accept what the counselors are recommending and reporting. So I don't have a problem. I think what the court will do in view of that, the court will appoint Ms. Osler as the counselor for reunification purposes in this matter. So Mr. Toth, if you want to prepare that order, submit it to the court under 7 days. The court will sign that and we'll get back in touch with you on Wednesday as to the other matters to set up those hearings. Anything,
Very good, Your Honor. Thank you.
Anything else, Mr. Sullivan?
Yes, Your Honor. The court has, on the prior occasions we've been in front of Your Honor, has indicated that the parenting time orders remain in place. And I understand that you've indicated today that with regard to the additional allegations of contemptuous contact on the part of the defendant, that you're going to put those into the evidentiary hearing to be scheduled with the first batch. But my client wants parenting time with his daughter. And so what are we going to do moving forward?
Well, court doesn't have, again, the court simply enforces its orders. That's the order. And so the court will enforce those. Mr. Toth, we're kind of in a conundrum. What do you suggest?
Yeah, Your Honor, I think that again, coming in recently, looking at what the court had originally ordered, it would seem to me that the immediate action needs to be bring Mr. Parks up to speed with procedurally what's going on and let him do his work, which he's indicated to me will be actually having a conversation with Emerson. Number two, it's accelerating the counseling. Since the last show cause hearing, Your Honor, I would say that my client has attempted to actually facilitate meetings between Emerson and her father. It's degenerated into Mr. Clark pulls in the driveway and is yelling out his car window to her as she's sitting on the porch. My client is not there. She's doing everything she can. Emerson, go talk to your dad. This has to get worked out. Emerson is 13 before this order will be entered. She's going into 8th grade. She's intelligent. Both parents know that. So things have changed, Your Honor. It's Emerson is sitting on the porch. Dad, please get out and have a conversation with her. And we can't facilitate that. So I think at this juncture, Your Honor, accelerating the input of Mr. Parks, accelerating the therapy regime is the best way to move forward here. Finger pointing as to how we got where we are, Your Honor, I think is counterproductive to where we are right now. There has been nothing that has been pointed toward my client as to what she affirmatively is doing, rather what she's not doing. And if it's not physically forcing her to go with dad's in the same position to physically do something himself. So there is no evidence of anything she has done other than the logic being dad's not getting his parenting time. We all agree. The reason for that must be that mom is poisoning that child against dad. And that's just not what the facts will support in this case, Your Honor. So going back, I think, accelerating the involvement of Mr. Parks, accelerating the counseling, just to get some third parties involved in here. And quite frankly, Mr. Parks will be an advocate for Emerson herself. So I think moving forward, those are the most important steps that can be taken.
Okay.
May I respond, Your Honor?
Well, yes, go ahead.
Well, even the front of the court's own frequently asked question sightings indicate that it is the obligation of the parent to prepare the child physically and emotionally for their parenting time. Second, the court's order is that my client receive parenting time. Third, for 13 years, there has never been a problem with his parenting time. Nothing has ever been expressed. If you look at the attachments, the photographs to our original motion, it shows my client with his daughter hunting, fishing, boating, snowboarding, all these wonderful things. And now all of a sudden, the parenting time stops for no reason. The last time, in midstream, the defendant indicated that, well, my client drinks alcohol. So the court, I think it was on May 30th, said, well, no alcohol to be consumed during parenting time. We said, fine. The court said Emerson should be able to have a phone during parenting time. Fine, she always has. So there's been nothing alleged to warrant a suspension of parent time. The court hasn't done that. So the court needs to, when the court says it's going to enforce its orders, let's enforce the order and have the parenting time recommence.
Well, we can do that, Mr. Sullivan, but I'm not going to do it summarily without an evidentiary hearing because the court doesn't have all the facts. I've got allegations and I've got responses, but we don't have any evidence at this point. What the court's going to do is, as suggested by Mr. Tullis, if we can get Mr. Parks to do an expedited, conference with Emerson and do maybe an interim report or whatever he can do so we have something as to some input. And further, all I can say is to the defendant, if it turns out at the evidentiary hearing that she is responsible for Emerson not going, then she's going to bear the brunt of that. It could be fines, could be attorney fees, it could be some jail time if it's her the one that's responsible for that. But I need to have all the evidence first before we can make that assessment, and I'm not going to do it summarily on allegations. So that will be the order at this point. Also, the only thing else is, Mr. Toth, if you could try to expedite it with Ms. Osler, because again, if it's Ms. Osler came in and said, well, I can't see him for 45, 60 days, then we might have to go with Ms. Cueta, because I don't want to put it off that length of time, being that Ms. Cueta is apparently on board to do it rather expeditiously.
I will do so, Your Honor. We'll get on it right away.
Okay, thank you.
Well,
Court will end this matter at 9:20.
Implementing a schedule for phone calls. My client has been continuing to see her counselor and complying with all recommendations from that counselor. My client has made and arranged appointments for co-parenting counseling and has been seeing Ms. Katz for co-parenting counseling. And she has had overnights with the minor child at least once a week through the month of May. So she's requesting that her parenting time be reinstated in full. The issues that she is having with that parenting time is Mr. Swims is not allowing the child to call her during his parenting time. And right now she has a very limited parenting time. So we're requesting that open communication be with both parties during their respective parenting times and allow Dylan to call whomever, whenever she would like. For our show cause portion, we're still having issues with Mr. Swims not using Our Family Wizard, as well as not contacting or arranging any of his appointments for co-parenting counseling with Ms. Katz. And then we also had 2 days of denied parenting time, one on April 8th and one on June 17th. So we're also requesting 2 days of makeup parenting time.
Okay. Mr. Swims, what's your response?
I actually have offered her 2 of the makeup days that she missed, but she also picked her up on Saturday for her 5-hour visit, and she refused to give her back, and she still has her right now. And yeah, I haven't talked to my attorney yet today. I think her office was actually closed today, so I'm not entirely sure what to do going forward.
Okay. Well, what's going to happen in this particular matter is obviously, we've got a situation now. Apparently, what we'll do is we'll set the matter for an evidentiary hearing. It does appear that, I guess at this point, you'll have to speak to your client, Miss Reed, but again, if she's kept the child, that is going to be problematic for her if she's not returning the child, because she's in violation of the court order, and the court will enforce its orders in this matter. You can't just unilaterally decide what you're going to do as it relates to parenting time or custody or things of that nature. So if in fact, Ms. Guaya, if you have the child in your care beyond the time required, then you're going to have to return the child. So
He refuses to talk to me.
ma'am, I don't know. Talk to your attorney. This isn't a time to take testimony. So what happens, you're going to have to make sure that the child goes back because that's what the order says. So that's what the court will do. The court will set the matter for an evidentiary hearing. I think I'm going to set this with the referee. It could hopefully expedite it and get the matter in faster that way. So we'll set it for a referee hearing, and otherwise, all the court will say is comply with the orders that are currently in place, or you'll suffer the consequences if you don't. So that will be the order. Court will end this matter at 9:30
Wow.
a.m. You're free to go, and you'll get a notice. It's probably in the next week as to when those hearings will be.
Wow.
Monday, July
Okay,
3rd.
thank you.
Thank you.
At 9:34 a.m. Attorney Paul Omloff is filling in for Attorney Boozer.
Okay. This matter is before the court on the plaintiff's attorney's motion to withdraw in this matter. They've alleged a breakdown of the attorney-client relationship, although unfortunately, Mr. Umloff, there's no reason stated in the motion, so I have no idea why. Maybe you could give me some insight on that.
Certainly, Your Honor. I am covering for Bridget today, but I have worked on the file with her throughout the time that Mr. Hall has been a client. Unfortunately, at this point, Bridget and Mr. Hall have a fundamental disagreement about legal tactics and strategy and the best route to take to get the best possible outcome for the client. And for that reason, Mr. Hall is no longer taking Bridget's advice, and we are requesting, therefore, that we withdraw. We can no longer zealously represent Mr. Hall at this time.
Okay. Mr. Hall, are you opposing, or you agree with allowing Ms. Boozer to withdraw?
I've got a couple, yes, I don't agree with this. So there's a couple things that she didn't do correctly. FOC can't uphold the custody orders because you guys didn't use the full names of my kids, because both my kids got DH. Their initials are DH. And I've been doing everything that Bridget's been telling me to do. I have not once not heeded her advice. There's a couple questions where me and her we argued a little bit because I wasn't understanding what she wanted, but there's not one time where I ever did not agree with what she was telling me to do.
Oh, okay. Okay, Ms. Hall, what's your position, if you have any, as it relates to this motion?
I don't have any input.
Okay. Well, these matters are oftentimes very difficult because obviously sometimes you just have a difference of opinion or how things are done. But unfortunately, in this matter, Ms. Boozer does not believe that she's able to represent Mr. Hall at this particular point. He doesn't seem to have the same issue relating to her, but again, it is a two-way relationship, and if in fact the parties are not able to communicate with the attorney, or the attorney is not able to communicate effectively with the client, that presents a problem for the client. So what the court is going to do, the court is going to grant the motion to withdraw. So Mr. Umloff, make sure the court get us an order allowing the withdrawal, and then Mr. Hall, you'll have to acquire other representation. Okay, sir?
Sir,
Your Honor.
before we go, I would like, before she's able to withdraw, I need her to amend the custody agreement, so friend of court knows what to do.
Okay, well, what's going to happen is I'm allowing her to withdraw, and so she's not going to be representing you. So whatever attorney that you get is going to have to finish the work, apparently, that she's had some issues with or have not been able to complete. So You'll have to get your other attorney to do that, or you can contact the front of the court and attempt to resolve things as well.
Dara gave me some information on how to do it myself. It's just the names that need to be put in there.
Okay.
Everything else is great. It's just since you guys use the initials, they
Okay.
can't.
Well,
You know, there's strict
I'll
guidelines for
I'll
friends.
tell you why that is, sir. What's happened is with a lot of the confidentiality and stuff that used to be where they put full names in, they put dates of birth, et cetera. And as a result of change in the court rules and statutes, they've now come out and stated that they should use initials as opposed to names. Unfortunately, as you said in your case, the initials are the same. That creates a problem. But it seems like you could, if you wanted to do an order correcting that and maybe you put one of the names in and not the other one, you could do that and send it to again to the defendant. If she agrees and signs that, then you'll be able to get the order entered and simply do a corrected or modified order with could be everything you have except for putting one of the names in, and that should be able to accomplish what you want, sir.
All right, thanks, sir. I appreciate
Okay.
it.
Your Honor,
Thank you. Yes.
Bridget did submit an order to withdraw as counsel with
Okay.
a motion.
Okay, we'll get that order and we'll get it
Attorney
entered.
Cindy Thomas for defendant.
Great, thank you.
Thank you. Good morning to everyone.
Good morning.
This matter is before the court on the plaintiff's motion for temporary custody, parenting time, exclusive use of the home, as well as other relief. Mr. Umloff, I think you've got probably the pleadings. I see that of things you've requested that some of them have they've agreed to in their answer. They agreed to joint legal custody. They agreed that he would not consume alcohol during the parenting time, and he agreed to exclusive use. So if you wish to address the other matters, you can go ahead, Mr. Umloff.
Certainly, Your Honor. The parties separated in early September of last year due to the defendant's excessive drinking and verbal abuse of my client. Since the separation, defendant only had sporadic overnight parenting time with Catherine and Serena, the twin children. Most of that happening in the month of May. He had approximately 13 overnights with Catherine and 14 with Serena. Since the filing of our motion, I would note he had no parenting time in June until the 24th, which was after we filed our motion. The two children did go with him and stayed with him. They are still with him, although Catherine expressed that she wanted to leave and due to the conditions that we've outlined in our motion in his home. And the defendant guilted Catherine into staying. My client has significant concerns regarding the condition of the home where the children are staying when they are with the defendant. The defendant drinks alcohol and smokes marijuana in excess, although I believe this is now a moot point as based on the response. Mr. O'Dowd is willing to agree to not drink alcohol in the presence of the minor children and not use any drugs, I believe, including marijuana. My client is also willing to agree to make that provision mutual, although she denies drinking in excess or using marijuana in the presence of the children. The children, when they are with their father, do not have their own bedrooms or beds and actually sleep in the den on air mattresses with their 12-year-old male cousin. They've reported that when they spend overnights with the defendant, they can hear him having sex with his new significant other, which makes them uncomfortable. He has multiple empty liquor bottles in his room. During the marriage, he drank regularly in excess of 2 pints of Jägermeister and when under the influence became verbally abusive of Sarah in front of their children. After a recent overnight with their father, both children were very visibly upset. One of them cried for 40 minutes due to his behavior. In response to the allegations raised in the defendant's response, my client did not have an extramarital affair. She has started seeing someone since the parties separated. The children have met this person on exactly one occasion when he dropped by the children's grandmother's house on Thanksgiving. But they had limited interactions with him and have not seen him since. The defendant raised in his response the allegation that Serena has dropped out of marching band and claims that this is due to the party's divorce and by implication due to my client's conduct. This is simply not the case. Serena dropped out of marching band because some of the other children in marching band were bullying her and making her uncomfortable. The allegation that Catherine's grades have slipped is also inaccurate. Catherine, unfortunately, has had struggles academically dating back to 7th grade, well before this divorce. My client denies ever grabbing Catherine by her hair. And it is, as it relates to the issue of child support, the defendant left his job at managing several C-store locations in September. He provided no explanation to my client. The longest explanation and most thorough explanation that we got was in his response to this motion. At that time, he was making $22 per hour and receiving monthly bonuses of approximately $750 each month. He now works at McDonald's, making, at the time of filing our motion, we believed it was $17 an hour. He acknowledges now it was $17.50. We submit that he is voluntarily underemployed, and for that reason request that child support be calculated with him being imputed his previous wage of $22 per hour and his monthly bonus of $750 per month. As it relates to the parenting time for the children, we are asking that my client have primary physical custody and that the defendant have parenting time on a schedule of alternating weekends with standard alternating holidays. Thank you.
Okay, thank you. Ms. Thomas?
Your Honor, first of all, I'd like to acknowledge that in my answer on number 7, letter L, I inadvertently switched the plaintiff and defendant in that one, so I apologize for that. As to counsel's comments, there's drastic disagreements. We are fine that they're willing to not have neither party use alcohol and or marijuana or any other any illegal drug, including marijuana, which of course is still illegal federally, during parenting time. I would ask that provision be maybe 8 hours prior to parenting time too, so that neither parent is starting parenting time on a situation where that they've been using which would be inappropriate. This is a situation where the plaintiff has set forth to the court disparaging remarks, disparaging comments, things to obtain what she hopes would be primary physical custody. That is not the situation in this case. Up until recently, when the parties separated in September, both parents were involved with the children. Both parents love the girls. Both girls love their parents. Both parents have participated in activities and events. Both parents have guided and molded the girls into what they are today. However, things have changed. The girls are old enough to see the light that shines on each parent. They're old enough to have a voice in their immediate future situation. Although they are twins and they are well bonded with one another, each daughter also has a very close bond with her parents. It's not the same bond as with mom as with dad. It's different because they're all unique. It's a situation where they were all living together in the same home. Mom decides dad needs to go, dad goes. It took a minute because it was there wasn't a lot of notice on that. And so it took a minute for him to figure out what the plan was. He then worked it out with his mom so that there is plenty of space at his mom's house. That it's not true that the girls are sleeping on the floor or in the same room with their cousin. They've had their own beds for well over a month now. It's the whole thing about them hearing defendants having physical relations with somebody is not true. But even more and greater than that, that these girls are connected with mom, they're connected with dad. Both of those relationships with both daughters are based on love. It's not that I mean, they love each of their parents differently. Each of the parents love them differently. They treat their kids differently, as any parent that's an individual does. A careful review of plaintiff's request for physical custody shows no real specific reasons why she should be the custodial parent. In fact, frankly, there's not a whole lot even about the girls, other than a few generalized remarks. In those remarks, again, attempt to disparage the defendant. Plaintiff alleges that defendant drinks and uses marijuana. She fails to state that both parties drink, and it was commonplace for them to enjoy a joint together. So it's not as though that there is any clean hands here in that particular regard. Defendant understands that plaintiff's use of marijuana has increased significantly. That is obviously not from his own personal knowledge, but that's his understanding. While he significantly decreased his use of alcohol, he understands that it does affect his children. He needs to not do that. And that's something he's been doing since the time of the separation. And quite frankly, just a little bit before that as well. The prior to when the parties first separated again, was kind of a surprise for Mr. O'Dowd Jackson. So he needed a minute to be able to get it set up so that he could have his children. He was at a place where he could have the children and that would be, workable. And it's interesting too that during those early days that the plaintiff would contact the defendant and invite him to stay at the marital home with the girls so that she would in fact be free to continue her ongoing extramarital affair. Although Mr. Umloff states this morning that the girls have not seen him only on one occasion, it was on Thanksgiving, that we believe is a flat lie, in that there are multiple witnesses that can testify other than that. However, that in and of itself does not necessarily make a bad parent, as we both know. What does matter is putting the children first and making sure that the children are in a good home, a stable environment, which is, again, the reason that Mr. O'Dowd Jackson decided that it was important that he try to work something out with his mom so that household was going to work, because it's an environment the girls are familiar with, they're comfortable with, everyone in that household loves them, and that need for them to have that at both houses was important to him. That's not necessarily what's going on at mom's house right now is our understanding. However, the backdrop is that there has been some issues, and although it was denied in this morning's argument, the defendant is absolutely willing to testify that he and others have seen plaintiff dragging Catherine to the ground by her hair. So that's, again, we're not saying she's a bad parent. We're wanting joint time with her, time with dad. But by the same token, there's not an angelic person wandering around here either in this particular case. Although Ms. O'Dowd Jackson alleges that she is willing and able to facilitate a close and continuing relationship with the defendant, it is first important to note that she would be unable to facilitate a close and continuing parent-child relationship if, in fact, a parent-child relationship, a close parent-child relationship already didn't exist. That's what they said, is that she's willing to facilitate a close and continuing parent-child relationship. So clearly there is one. And this is just argument for the sake of making argument about a reason to have sole physical custody, and that's inappropriate. In addition to that, she indicates she would not, do anything to not continue that. And yet she's asking, the parties have since. So when they first separated, it was a little bit, until Mr. O'Dowd Jackson, it was a little bit more mom than dad, certainly. But for the last 2 months, it's been week on, week off, every week. And the only time that it wasn't is that there was, in June, the parties agreed that mom was taking 2 weeks and then dad was taking 2 weeks, and it had to do with their individual respective plans for vacation time and whatever. So that was a change. But other than that, it has been week on, week off since May. The girls are doing well with that particular situation. In fact, as they've indicated, they would like to continue that situation. So we don't want to interfere with the relationship, and yet we're asking that right now, under the current situation, it would be on an annual basis, it would be 182 and a half overnights. Yet Ms. O'Dowd Jackson is asking that Mr. O'Dowd Jackson go from that to 52 overnights, plus maybe a token overnight holiday. They didn't even ask for additional time for summer, like summer, even under the old standard quote unquote parenting time, included half of summer. We didn't even make an allegation or an interpretation of that by the plaintiff that was even appropriate. So clearly this is not about that. What this is really about in our view is this is about using hearsay, and they are hearsay because there's no way many of the allegations that she's made can possibly be known. It's using that and innuendo to obtain control. And the real crux of the matter comes to play in the allegations regarding child support. Plaintiff asked this court to impute income to defendant when she supported his decision to change jobs. And frankly, even if he hadn't have changed jobs, it's very clear based upon what was happening at the C-store. By the way, one single C-store, he never managed more than one. He managed different ones, only ever one at a time. They were looking to replace him. So even if he would have not left the C-store, they were still looking to replace him. He still wouldn't be working there. Rather than just sitting and dealing with that, he decided he would prefer to go and find a position that has upward mobility. The guarantee amount of potential, and it's truly a potential bonus in his past job, was based upon not only his personal, job performance. It was also based upon how well the C-store did that particular month. So if the C-store did well, fine. He had an opportunity. If his work ethic and habits and whatever, if he did all of the things he was supposed to, then there was a potential of a bonus, but that wasn't in any way guaranteed. And it was based upon, the first step of that is based upon the C-store had to be making a profit that month, which is obviously not necessarily in the control of any of the individual employees. At this particular time, he is making $17.50 an hour. He's working 40 hours a week. He is on the management path for McDonald's. They are at this point seemingly happy with him, and it's a situation where he's got potential for significant growth with the company, and based upon particular his past management experience. Yet at this point, the plaintiff, she wants the kids, she wants the money, she wants it all, and it's not equitable. Frankly, it appears to Mr. O'Dowd that she's very consumed with her boyfriend and her lifestyle, and she is putting that before her daughters. Based upon all of that, we're requesting that a continuation of the status quo, with the parties enjoying week-on, week-off parenting time and sharing major decision-making of the girls under the provisions of joint legal custody. I understand that is an agreement at this point. Mr. O'Dowd Jackson is also requesting child support be set pursuant to the Michigan Child Support Formula using actual party earnings, and that the parties alternate holidays pursuant to the Calhoun County Family Law Committee recommended holiday parenting schedule. He is further willing to stipulate to not drinking, as we now know, and apparently Mrs. O'Dowd Jackson is as well. And we would ask that include both drinking, marijuana, and any illegal substances, and that it would also include 8 hours prior to their parenting, just so that at the beginning of their parenting time, both parents are alert, knowledgeable, and are in tune with their children. Mr. O'Dowd Jackson also requests that if this court is inclined to grant the request for exclusive use of the marital home, which he's fine with, that he would have an opportunity to go to the home, get his remaining personal things that are not marital things. We're not asking that. And also that he have an opportunity to inventory the home as far as the marital items that are there, twofold. First of all, because we know that to make a property list fully and completely, he has to have access to do that, which eliminates the possibility of, at the end of a very long divorce, that we don't know what all the personal property is. Also, it's his understanding that already marital assets have begun to be dissipated, including an antique bed frame that was like his family's thing. So he would like, again, an opportunity to go there to get his remaining personal things, and also to be able to do an inventory. And that was at my request initially that was happening. Also, that she meaning plaintiff would be solely responsible for all of the there's no mortgage, but all of the other expenses related to the marital home. And just so the court is aware, with the week-on, week-off parenting that's been happening, Mr. O'Dowd's week would start on July 7th, and they switch on Fridays at 6. They just had an up north, and a little bit longer trip up north, and so they're doing a little bit of makeup right now. But anyway, this would be Mrs. O'Dowd's holiday, would be July 4th, so alternating after that. And then Mr. O'Dowd's first full week of alternate parenting would be the week beginning on Friday, July 7th. Thank you.
Okay, thank you. Well, what the court's going to do in this matter is the parties have no dispute of joint legal custody. The court will grant to the parties joint legal custody. The court does believe that, again, in this matter, the status quo, other than just recently when they've switched some weeks, have been with the girls in the plaintiff's care. The court's going to continue that and grant to her physical custody. Court would grant to defendant standard parenting time, alternating weekends, midweek, as well as alternating holidays and alternating weeks in the summer. The court would, at this point, calculate support based upon his current income of $1,750. The court can adjust that when we have an evidentiary hearing or trial if the court believes that, again, imputation is necessary and appropriate at that time. The court would order that the parties would not consume alcohol, marijuana, or illegal drugs during the time that the children are in their care or for 8 hours before that. Court would also, in this matter, order that the girls, while in the defendant's care, have their own room, that they're not in a room with a 12-year-old male cousin. And court will grant to the plaintiff exclusive use of the home. the court will allow the plaintiff to box up, if you would, the defendant's personal items. He can pick those up when they do a parenting time exchange. And again, if there's some other items that are not included at that time, then you can exchange the list with the attorneys. And if you can't work it out, you can come back into court at that particular point. So that will be the order. Mr. Umlauf, you can prepare that and submit it under a 7-day notice of entry.
Your Honor,
Thank you, Your Honor.
can I ask a further question, please?
Yes.
Then it doesn't sound like the court is allowing Mr. Odell Jackson.
I'm not, Ms. Thomas. I didn't address that because I wasn't going to do that at this point.
Okay. Then my question is, can we include in the temporary order that there would be no further dissipation of marital assets, because that is what has apparently already happened?
Mr. Umlauf, I don't assume you'll object to that.
I do not, Your Honor. My client denies dissipating any marital assets, but certainly that can be put in the order.
That's fine, Mr. Umlauf, include that in your order.
Thank you, Your Honor.
Okay, thank you. Court will end this matter. This matter is before the court on the defendant's notice for entry of order in this matter from a prior hearing. I guess I'll ask Mr. Postmus, are you opposing the entry of that order?
Yes, Your Honor, I am.
Okay, and what's the basis for that?
The basis for that is a number of reasons. One, it's taken her over 3 years to execute her QRDO. I feel at this point, she's doing it merely out of vindictiveness. Reason number 2 is she has came into this court already and lied to get possession of the marital home, stating that she had the ability to refinance it when she did not. She had her mother refinance it. 2, stating that she had no intent to sell. That home is now currently listed as pending for sale for $71,000 more than she attained it for. She listed it for sale within 2 weeks of getting the quit claim signed. She had every intent at that time to sell the home and is now in the process of selling it. So basically cutting me out of any equity from the sale of that home. 3, I'm still paying her alimony while she is currently living with a boyfriend. I feel that she has taken enough, more than her fair share already, and that this measly $6,000 that she'd get from my 401k is just beyond extensive.
Okay, thank you. Mr. Padal?
Yes, good morning, Your Honor. In large, I don't think that anything that Mr. Postmus has raised is relevant to the issue that's before the court today, Your Honor. Judgment was entered in this case on 6/25/2020. In that judgment, Ms. Postmus was awarded half the retirement account. Case law would state in statute further that this judgment is enforceable for a period of 10 years and can go beyond that if Ms. Postmus renews the judgment. So the fact that it's been only 3 years is well within that time, Your Honor. Additionally, any equitable value that Mr. Postmus is alleging that he may have in the home, 1, is not tied to Ms. Postmus's rights to have her share of the equity out of the 401k, and 2, is preserved in an order that was entered before this court on a separate matter. So if Mr. Postmus has an issue with his belief that he thinks he should receive some sort of equity out of the home, he has a remedy for that based on the prior order of this court. So we're asking that the court enter this QDRO consistent with the terms of the judgment, Your Honor.
Okay, thank you. Well, Mr. Postmus, in this matter, as Mr. Podol cites, that again, if you have issues, you have a right to have those issues heard. You can bring those before the court on a motion seeking whatever relief you request, but it's not proper at this point to interpose and those particular objections or requests as it relates to the order, which is consistent with what the court ruled and consistent with the judgment in this matter. So the court is going to grant the order as submitted by Mr. Padol and Mr. Postmus. If you have other issues, you have a right to file your motions with the court. The court will hear those at that time. So the court will conclude this hearing.